Hey everyone, Harry here to talk about Donald Trump's brief on the merits in the immunity case in the Supreme Court to be heard April 25th. All right, for the most part, he really is just, I guess we're not doubling down at this point, we're 16ing down or whatever on his same pretty damn tired arguments. The headlines blaring around the country is he's saying that if the Supreme Court doesn't recognize immunity, it's de facto blackmail and it will totally hamstring presidents going forward and they'll be scared to take any action because of the threat, the sort of criminal prosecution as soon as they get out hanging over their heads, etc. He has argued that, but news coverage seems unaware that that's what he's been saying pretty much all along. One of his major arguments, and it's an argument that was demolished and very painstakingly by the unanimous Court of Appeals at the D.C. Circuit in the decision that the Supreme Court is now reviewing. It's just a way of his saying that immunity is necessary. Well, the first submission in this argument is we've never had presidents be subject to criminal prosecution, so it can't really be in the Constitution. I should not chortle, but there is really an obvious answer that screams out to this recurrent argument, which is, we've never had, even in the Civil War, presidents no less try to aid insurrection and literally resist the peaceful transfer of power, the hallmark of a democracy. But the D.C. Circuit was much more detailed. The first thing they make clear is, no, that's not true. We've been living with this threat. How can you tell? Richard Nixon. Why does Richard Nixon need a pardon if he doesn't expect that his actions while in office subject him to criminal prosecution? And indeed he does. Second, the rule that Trump is arguing for would essentially import into the criminal context what the court has recognized in the civil context. If you're acting within your official or within the outer perimeter of your official duties, you can't be sued civilly for conduct that happens while you're president. But there's much more weighty considerations for actual criminal prosecution, and to say you're above the criminal law and the state's compelling and the federal government's compelling interest in vindicating its criminal law is a lot more brazen and concerning a kind of prospect. It's the vindication of those laws against the most antisocial conduct out there are more serious. Third, he tries to ground this in some separation of powers kind of considerations, but the D.C. Circuit makes it clear this is just some kind of executive supremacy argument, because judges are subject to the criminal law, legislators are subject to the criminal law, so why not presidents? Anyway, they really demolish it, and Trump's argument in his brief is nothing new. Then the other main argument there is also nothing new. It's this kind of wacky refrain involving the hoary fountainhead of judicial review itself, Marbury versus Madison, which has a little snippet that says certain presidential actions may not be reviewed by the judiciary, but it's completely clear from that case and others that those actions are ones that are given over to a president's discretion by law. Maybe certain conduct of foreign affairs. You're not going to be able to bring an action against the president for anything that's completely in a president's discretion. But complying with the criminal law is not something that's in the president's discretion. It's sort of a bootstrapping argument here by on Trump's part. And the Marbury versus Madison dictum is, really not germane here, but he does it again and again. Okay, so really it's just the same arguments that the media are trumpeting, but they've missed a big one. He's added an important argument here that's designed to attract the attention of conservatives. The argument he's added is that federal criminal laws may not be made applicable to the president unless Congress has made a statement of express intent to do so. Now, this actually invokes a series of decisions. One's in the 11th Amendment having to do with sovereign immunity, but where certain constitutional values, you might call them conservative constitutional values, are at play, the Supreme Court has kind of out of nowhere created rules of construction that say we won't lightly assume that Congress meant to do this kind of, they can do it, but we won't lightly assume they mean to do it and put this kind of pressure on the separation of powers overall unless they say so expressly. So if that were true, it would actually mean that you go through the federal criminal code, starting with Section 2, aiding and abetting, and all the way down to include 793, the statute he's charged with violating here. And only if Congress had appended a statement, this applies to the president, could you actually use it against the president. That is, basically 7/8 of the way toward the special above the law treatment of the president that Trump is seeking, period. But it does have a kind of, it's crafted expressly, I think, as catnip for, Alito and Thomas and Gorsuch to basically, really spring Trump without actually taking the stand on the indefensible proposition that the president is above the law. I don't see it having purchase here, but I wanted to explain it to everyone, especially because the coverage of the argument just seems to have whiffed on this. So there you have it. The stage is half set with what Trump has to say. Now we'll hear from the DOJ, and that's in the person of one Michael Dreeben, who it's worth spending 30 seconds to tell you about. He was for many years the person in the Solicitor General's office. That's the office that litigates in front of the Supreme Court, who was the specialist in criminal law. So he would be the one who would come up there for criminal law arguments, enormously respected by the justices, both for oral and written advocacy. So Trump's brief, I should have said this at the outset, is credible. It's not a completely crazy product. It's solid, but you can expect Michael Dreeben to really come in strong and the justices to be influenced. Nevertheless, the game here is that the justices framed their own question presented, and that is whether, and if so, when a president enjoys immunity. And just notice that I see no scenario where the Supreme Court of the United States or the federal court system overall holds that Donald Trump is immune for the conduct alleged on January 6th. But I do see scenarios where the Supreme Court recognizes in the abstract situations where a president might be immune even from criminal law. If they say any situation like core executive function, there's some kind of immunity from criminal process, Trump is going to argue that his, absolute unconstitutional, beyond the pale conduct somehow fit in that category. And where will he argue? In the district court. That is, if the Supreme Court recognizes any instance of immunity, it will prompt a remand and a decision by the district court. He won't be immune, but that decision itself, it seems to me, will be subject to a quick, but nevertheless, additional up and down movement to the Court of Appeals, which will, would affirm, and then the Supreme Court, which would deny review probably. But what is that? Another month, even if it's hyper quick. So that prospect of the Supreme Court embedded in the question presented of finding something different from what the Court of Appeals found, some instance in which immunity from criminal prosecution obtains, carries with it the risk of yet another shorter, but we're really short on time here generally, delay even after the Supreme Court rules in this immunity case. Okay, so Trump's brief, nothing new except for this weird argument that might be designed for conservatives that says Congress has to be express. Michael Dreeben coming, and just the general specter of some kind of holding that prompts a remand and then another appeal by Trump that has yet another, if not so long, but we have very little time to work with, delay. So there you have it, awaiting now the DOJ and Michael Dreeben's retort to Trump. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.